say you got a 70-year-old lady who just hit a blunt and is looking at Instagram on her phone and blows a stop sign, we can show that, you know, she's more than just your basic level of negligence. When it comes to the ways that different state laws affect the handling of a distracted driver case is through the level of negligence that we can pin on the person who caused the accident, right? So typically, if you have a normal motor vehicle accident, it's called negligence, or I could call it the basic level of negligence, right? And a good example of that would be, say you have a sweet old lady who comes to a four-way stop, they run a stop sign, and hit somebody who got there first. If she's paying attention, you know, isn't distracted by anything, isn't looking at her phone, isn't eating anything, she was obviously at fault for that accident, but it's just kind of that baseline or simple negligence, okay? She shouldn't have ran the stop sign, she should have seen somebody else coming, etc., etc. There are a lot of scenarios with distracted driving where we can try to show and ultimately be successful at showing a higher level of negligence. Depending on the state that we're in, it can be referred to as recklessness, wantonness, or even willful or malicious conduct, okay? And those are kind of fancy legal words, but the better way to describe it is extreme negligence or recklessness, you know, super negligence, I guess. But an example of that would be, say you've got that same four-way stop sign and there's a 17-year-old kid who runs a stop sign, but we can show that he was intoxicated or he was looking down at his cell phone and that's why he ran the stop sign. He was obviously still negligent, meaning he was the one who caused the accident or liable, you know, for the accident, but his actions rise to a higher level of negligence because he was intoxicated or because he was texting, looking at his phone, looking at social media, emails, anything, you know, looking down at that. And that has an effect because if we represent the injured party who was hurt by the person, you know, let's say that our client or the injured party's damages are $10,000. You know, medical bills, pain and suffering, some wage loss, $10,000. For the first example with the old lady, that basic level of negligence, you know, we're going to get $10,000 from that, okay? In the second example, if the 17-year-old kid who runs a stop sign, and if he is intoxicated or distracted by his cell phone, texting, looking at his cell phone, our client's damages are the same, meaning there's still $10,000 of damages to her. But if we can show that he had a higher form of negligence or recklessness, then under state law, it makes him susceptible to what's called punitive damages, okay? Punitive damages are to punish wrongdoing and to deter that kind of conduct, right? Because we want to say, you know, if it's in Kansas, the Kansas legislator wants to say, hey, we want to discourage drunk driving. We want to discourage texting while driving. And that exact same case might be worth $50,000 or more when the person who caused the accident is distracted, and we can show that, you know, they're susceptible to punitive damages.